Good morning, ladies and gentlemen. Today's session on principles is the second part of the relevance of human rights to health and social care. Very timely at the moment with concerns in the Conservative government about immigration, but I'm just concentrating on its relevance, their relevance, the human rights relevance, not the Conservatives' relevance for health and social care. So the recording is on, and I'm going to just go straight into the session and hope that you stay for questions at the end. We looked last week at how human rights, properly understood, actually work in the British Constitution and how they pervade and trickle down through welfare legislation that's full of woolly concepts. So last week we looked at Articles 3 and 8. And we're going to look at Articles 5 and 9 today. Article 5 is one's right to liberty and security of the person, through which the deprivation of liberty safeguards and best interests interventions have effectively emerged. To me, that's two sides of one coin. It's got relevance to lots of situations in health and social care where intrusions into this so-called right are actively permitted by the Human Rights Convention and our own Act. So, for instance, deprivation of liberty for people of unsound mind, although it doesn't sound very polite, it's the most obvious one of relevance to people who are in need of health or social care, where their capacity on specific issues is lacking. And it's not just for others' protection, but for the delivery of services to that person, and in the protection of that person against him or herself, their own lack of insight, or their psychotic state. If we didn't have this form of backup to our own legal system, we would be back in the dark ages of medieval times where people could just take their spouses to an asylum and sign them in having paid money. And that wouldn't be so very good, I don't think. Article 9 is about a right to respect for one's conscience and religion. And whereas Article 5 is a limited human right, this one is limited in a different way. It's still big in adult social care and health because it pops up in cases or ombudsman's reports, for instance, about what your direct payment can be spent on, what counts as an appropriate or suitable care setting, even if it costs more to deliver halal or kosher food, for instance. It can impact on what one's family and friends should be entitled to expect of a care provider by way of supporting engagement with the family's religious tenets, if one is declining cognitively or lacking in capacity. So that's how those articles of the Human Rights Convention can be basically relevant. And I'll concentrate on the right to liberty first of all. Under Article 5, deprivation of liberty is positively allowed if you've been found guilty of a crime and sent to prison. Where would we be without that? You've not done something a court has told you to do or that you're legally required to do. There's a reasonable suspicion that you've committed a crime, or someone is trying to stop you committing a crime, or they're trying to stop you running away from a crime. So that's the kind of provisions that extend to making bail legal. If you've got a mental health condition which makes it necessary to detain you, unsurprisingly, that is provided for, and that is permitted under our own Mental Health Act. And this is one that has resonance for the COVID era. If you're capable of spreading infectious disease, or you have a mental health impairment that is sufficiently serious to warrant detention, you can also be legitimately deprived of your liberty. Even if you're under 18 and a court has ordered that you are detained, you can be deprived of your liberty in that way. Attempting to enter the country illegally, or action being taken against you in relation to deportation or extradition. So the right to liberty is big, but then there are exceptions to it, which every society needs. But what's special about Article 5 is that it's got due process rights on its very face. So, for instance, in Article 5.4, it says this: anyone who is deprived of his liberty shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court, and his release ordered if the detention is not lawful. So that's why we've got the Court of Protection in this country. This is the reason we have it, and not just the administrative court. We have the Court of Protection judges actively making direct best interests decisions. It can't be a judicial review judge who's just looking at whether the decision was reasonable, defensible, rational, etc. It's got to be a specific judge making a direct decision. And everyone who has been the victim of arrest or detention shall have an enforceable right to compensation. And that's why people who are being deprived of their liberty in our care homes and hospitals and in supported living have a right to Human Rights Act damages at this very moment. Not all of them get very much, because if in fact it would have been in their best interests for them to be kept in that benign regime, and the paperwork just hasn't been done, that's called a technical breach. But if in fact there's a genuine debate about the compassion and benignness of the regime that somebody is being held under, or if in fact they've got capacity and they shouldn't be amenable to DoLS in the first place, then they could have a substantive right to damages. For those of you who want to see things from the mental health perspective, you can look on Mind's site. And Mind's site is well set up to be in plain English for people who are potentially not very well or are caring for people who are mentally not very well. And it explains that there are exceptions to the right to liberty. It has to be done lawfully, and there are procedural safeguards such as the Mental Health Tribunal. There's also the rights under the Mental Health Act to advocacy, etc., to ensure that people can actively access those rights. IMHA advocacy does not depend on somebody's capacitated consent, even though a person can refuse an IMHA. People should be bright enough to realise that that refusal might be completely incapacitated and not valid. Social care detention, the idea that some people, just to be looked after, have to be deprived of their liberty, has its roots in Article 5. I've been reading up what Lucy Series has to say about this, and it's an interesting read. She's a professor of social care law at Bristol University. So the safeguards against deprivation of liberty just being arbitrary and willy-nilly are that you have only to be deprived of your liberty by a procedure that is clearly prescribed by law. And as we've seen, you have the right to go to court to get that checked out. Some of you will know the Cheshire West case, the acid test from about 2012, when the UK's Supreme Court confirmed that whatever a person's age, a person's care arrangements will give rise to a deprivation of liberty, which must be lawfully scrutinised if there are three conditions. One is that there must be an objective element of confinement in a particular restricted place for a not negligible length of time. Being in the back of an ambulance with the door locked is never going to count, but being in a care home where you are not free to leave will. There has to be a subjective component that the individual concerned has not or could not consent. And that's why DoLS is only a process that's available to people who lack mental capacity in relation to the regime of care and treatment that they are being, I won't say subjected to, because that makes it sound bad, but and I won't say enjoying, because that makes it sound too good, but I'll say to which they are subject. And then the third thing, which people sometimes forget about, is it has to be the state. It has to be a public body that is doing this. And you would think, well, what about all of those private people who are just bunged away somewhere when they lose capacity by members of their family? How do they then get to be concerned about deprivation of liberty if it has to be down to the state? It can be attributable to the state if the state is aware of it. So because safeguarding is not limited to people who are being publicly commissioned for, but extends to people in our society who are also being privately cared for, there is a route through to hustle about somebody's predicament if they've got even one person on their side. I'm not going to make this a lecture about deprivation of liberty safeguards, or in fact the liberty protection safeguards. If you're interested in this sphere, I expect you'll know that we were going to have DoLS safeguards replaced by something called the LPS. And that was going to happen this year, it was going to happen last year, it was even going to happen the year before, but it's now been announced that it ain't going to be happening. And I thought it would be interesting for people just to see in these slides that there is a slide about what the government itself set out to do. By acknowledging that the DoLS system was not fit for purpose and didn't, in fact, deliver on people's human rights. So there was a complicated but well-advanced process before implementation of the liberty protection safeguards. But about 4 or 5 months ago, it was announced that the government just couldn't see their way to sorting it out in what will be election year. So their best intentions have been shelved. The theory was that there would be more streamlining and less intrusion, that it would be more proportionate, that all sorts of protected, disabled and discriminated against people would have access to the same protections. So there would be equality. There would be equality, especially for people with disabilities and mental disabilities. The process was going to be improved. It was, of course, going to be made cheaper, leaner, meaner, as it were, for local authorities. It was going to be as straightforward as possible, so it wasn't going to set off a massive training fest. People were already beginning to learn about it, although the regulations had never come out. So, in fact, trainers couldn't come off the fence and actually pontificate about what would have to be done. How we feel about that is that it's inevitable. It's part of this current government's relative bankruptcy in terms of ideas and staffing, because so many cuts have been made across civil service departments as well as in the sector. Not only has the care costs cap been shelved, but the liberty protection safeguards have as well. And so it seems to me that we have got really no further forward. What shocks me is that local authorities had kind of been thinking that DoLS wouldn't matter because we would have the liberty protection safeguards, but now we're not going to have them, or may not have them, depending on which party gets in. Then we have to think about whether all of that work was actively for nothing. I thought people would be interested to know that there's a separate set of justifications for depriving children of their liberty that also come from Article 5(1)(d). It's allowing children to be deprived of their liberty by lawful order for the purpose of educational supervision. And that therefore means that there is the possibility of an order under Section 25 of the Children Act for secure accommodation. And under the Mental Health Act, children can be sectioned as well. Their deprivation of liberty, if they are merely lacking in capacity, can be scrutinised by the Court of Protection. if they are over 16, 16 or over. And for people who are under 16, the High Court uses its inherent jurisdiction, or the matter goes to the family court because a local authority is involved. This is just a sheet of very large, I don't know why it's so big, but it's in your face. It's a very large sheet of links to useful sources of information on deprivation of liberty and its human rights underpinning. So you can photograph that or copy it down, or if you're paying for the PowerPoints, then they will work. It will work as a link when you bring them up. So I thought that because Article 5 is so well known, we'd spend a bit more time on Article 9. And this is an article that doesn't get talked about very much. Everybody just kind of thinks it's there because we all know that religion matters, even if we are rabid atheists. So Article 9 is freedom of thought, conscience and religion, and it includes the right not to believe in anything at all. It includes beliefs like veganism and pacifism, so it doesn't have to have a religious connotation to it. It's freedom of thought, conscience and religion. The freedom to change your beliefs at any time and not to be forced to believe in something. However, like the other human rights, most of them we've been looking at, it can be limited where it is necessary in a society and fair to do so, to make some infringement of this liberty in order to protect public safety, public order, health or morals, and the rights of freedoms of other people. In a bit more detail, it is about manifesting your religion or belief. And that's why I'm interested in its impact on social care arrangements. Is it part of well-being? Is it part of somebody's need? Is it part of the appropriateness of the response to need? Article 9 in its own writing refers to manifesting religion or belief in worship, teaching practice and observance. And so in relation to worship and observance, it would be relevant, would it not, in a care home? It would be relevant to somebody's care package. This freedom to manifest your religion or your beliefs, it's subject only to such limitations that are prescribed by law and are necessary in a democratic society for those particular headings. As we've said, national security doesn't appear there, interestingly. The European Court of Human Rights has emphasized that there must be an open forum for beliefs and opinions, for pluralism and democracy to work. And atheists and agnostics can claim the protection of this right, and they do. Cases have been brought by Humanists UK about people's need or desire to be married in a humanist ceremony, not merely a civil partnership. And in particular, a kosher diet and the tenets of being a Jehovah's Witness have been discussed in European court cases. Article 9, though, only protects actions and gestures that are intimately connected with a creed or a belief. So you can't just make one up and say, everyone should know this about Islam, or everyone should know this about being Jewish or Buddhist or whatever. And an example of something that isn't close enough is it emerges from the right to die cases. Cases where really severely disabled people or severely ill people have tried to contend that we should have a right to die, or also claiming that the rules that make it potentially dangerous to help somebody commit suicide, even though we've got the DPP criteria for the best indication as to when you will not be criminalized if you help somebody to die, so long as you're squeaky clean about it. The cases have argued that our country does not go far enough and that this is a breach of human rights. So the argument was put forward that your freedom to choose the manner and timing of your death should not be restricted by legislation, that's the suicide legislation and assisting a suicide, legislation that the proponents were saying had been fueled over many years by religious sensitivities. So that argument was rejected the last time it was taken to the European Court. It's regularly re-challenged because countries all over Europe now, even Catholic countries, are adopting right to die legislation in various guises. And that's why people in this country keep taking a pot shot at that principle that is very firmly established in this country, that it is a criminal offence to help somebody commit suicide. So I thought you'd be interested in this piece of Court of Protection law. The blue link is the link to the judgment. And it was a case about mental capacity in relation to a young man with severe cognitive disabilities. He was continuing healthcare funded, and he was 39. So he's not that young, in fact, but he's from a Punjabi family who were devout Sunni Muslims. He had a halal diet, even though the gentleman himself would not know that the food he was eating was halal, or the significance of the source or preparation of the food for religious sensibilities. And that's because he's got a profound learning disability and functions intellectually only at the level, I think it was, of a 3-year-old. So he had atypical autism. He was engaging and he enjoyed the company of his family, and his family enjoyed him. He would go home to them, say, 3 times a week. And his carers were commissioned to provide personal care, meal preparation, and accessing the community. They were used to having to intervene in relation to lawful restriction, because he would be unpredictably volatile, sometimes severely so. If he was stressed, he would kick, bite, grab his carers, punch, or spit. And sometimes it could happen dramatically and without warning. Sometimes he just awakes in an agitated mood. So the issue was not whether it was lawful to be doing this to him, but whether fasting during Ramadan was something that could be in his best interests. And the question of ritual shaving in relation to his armpits and other bodily areas. Now, remember, this is a profoundly disabled man. So a declaration was sought by the local authority that it would not be in his best interests to support him to observe Ramadan, nor be subjected to shaving. His family accepted the fasting, but not the issue about the body hair. In relation to the fasting, he'd never been expected to fast. His father, though, had been able to shave him. And there was evidence that it could be done safely, but if it wasn't his father, and I think it was his brother, it would need 3 carers to manage the risk. That in itself would make it possible, but it might be claustrophobic, and it probably would elevate his mood, and of course it would cost 3 times as much. The family's practice was to engage in daily prayers and fast and celebrate Eid, all activities clearly associated with Islam. The dad had stopped taking the man to the mosque for prayers because it was occasionally disruptive to others. His facial hair and his beard was regularly shaved with the use of an electric razor. And the professional's evidence was that just as he wouldn't have understood halal food, he would have had no real appreciation of the religious significance of the family's rituals, even if he enjoyed the regularity with which they were performed, and he appreciated an increasing familiarity with the rituals. So he's become effectively accustomed to these things happening, and on a good day, it could be done relatively safely. On a bad day, though, it wouldn't have been a good idea. So as far as the court was concerned, they needed to apply the Mental Capacity Act, and that would mean identifying first and foremost what were the actual issues on which this gentleman's capacity should even theoretically be tested. He has a presumption, but remember, if he wobbles in relation to understanding or retaining or weighing or communicating, then on the balance of probabilities, he probably lacks capacity. So the judge set out what the issues would have to extend to, that he would be needing to be seen safely to be managing to do. If he couldn't understand these things, then he would lack capacity. Secondly, in relation to the trimming or removal of pubic or armpit hair for religious or cultural reasons, a person in that situation, to whom this was to be done under best interests, would need to understand, or would rather need to be incapacitated in relation to which parts of the hair are being removed, whether the reason is religious, or in the context of his personal care, is it just to do with good hygiene? If for a religious reason, what is that religion, and what is it that the religion says is important about this, and what the consequences would be of making a choice to have one's hair trimmed and removed, and what the consequences would be of not having that done. So if a person is incapacitated in this regard, then a decision becomes possible in terms of best interests. If there is no incapacity, then this is the gentleman's decision rather than anybody else's. The judge's view of the facts for capacity were as follows. The social worker has significantly misunderstood the gentleman's capacity to understand and reflect the concepts associated with religion. He has no understanding of the concept of Islam, and I find that he has no capacity positively to feel proud of his religious heritage, nor is he able actively to associate with an identity or a culture, although he is undoubtedly associated by his family with that identity or culture. While he may give the superficial appearance of engaging in prayer by responding to the familiar practice of the adults in the family turning to prayer, he holds his hands up or places them behind his ears, he has no understanding of the purpose or higher meaning of the act of prayer. And while recognizing the religious significance of the hair trimming procedure for a person with capacity, it is argued that as he does not have capacity, there is no religious obligation or significance for him in the procedure, and he is absolved, even by the tenets of the Islamic faith, from any expectation of compliance. On the other hand, there is a risk to him in attempting the trimming of the hair that he or others will be harmed in the process. So in this situation, taking a balance sheet approach about whether it could be in his best interest to continue this very full-on intervention, the balance sheet approach worked extremely well with the tenets of Islam. No hurt and no harm is a cardinal principle of Islamic bioethics. Avoidance of harm has priority over the pursuit of a benefit of equal or lesser worth. It would be wrong to create a situation in which observance of Islamic custom would or would be likely to cause harm to the person or his carers. If there is a risk of harm, then this principle of Islam would absolve even the capacitated person from performing an obligatory requirement. I recognize that this is to the gentleman's benefit, that his family feel he is being enabled to follow Muslim custom to the fullest possible extent. But this is not a case in which I believe that he will be viewed any less favourably or affectionately by his family or wider community if the hair trimming is not carried out. He is, within the family and the community, much loved. If the community know and understand the fundamental principles of Islamic bioethics, I would have to add. So that's an interesting case. And then at the opposite extreme, we have the whole question, which is more relevant to the Care Act, of the scope of direct payments. This is one that mentions religion. I had to do quite a bit of digging for this one to make this one come good. So in the direct payment part of the care and support guidance, there is a very clear edict to local authorities from the government that direct payments should not be stymied by unreasonable restrictions placed on the use of the payment, as long as they are being used, the money is being used to meet eligible care and support needs. Does this mean that it can be spent however one likes? Nah. Did it ever mean that? No, it did not. You won't have a direct payment unless you've got a budget, and you won't get a budget unless you've got an eligible need in the first place. I would say that people are still being encouraged to care plan for themselves as much as they can, informally, but it is on the assumption that they'll be using assets and strength first these days, so that the council saves the money and can reduce the actual budget for what has to be physically paid for. In the old days of personalisation, there was a feeling, there was rhetoric to the effect that you could keep any savings that you made out of your budget, because in fact it had been allocated to you, and as long as you didn't do something illegal with it, you could keep the money. It's a very old-fashioned idea nowadays because of the difficulties that councils are in. They use every ounce of their powers to reclaim unused sums of money. It's public money. It doesn't become completely the individual's, not in the beneficial sense. But the thing I found was a report from the Ombudsman a couple of years ago involving Buckinghamshire. They found a client with a direct payment had spent it on the 3 R's: religious instruction, reflexology, and rugby tickets. They decided not to reclaim the money because Buckinghamshire accepted the Ombudsman's view that if you don't ever make it clear to your clients what they could and could not spend it on, then it doesn't sit well coming from the council 2 years later that they thought that this was an unlawful spend. So here I'm going to put that on its head and point out to people that in Section 8, counselling is part of the set of lawful, reasonable ways of meeting a need that are set out in Section 8. So depending on what this religious instruction amounted to, it's not so very far out or wild or radical to say that it could be good for someone's well-being if it counted as counselling and in the context of an eligible need for social inclusion in the local community. Armed with Section 8, you can make the words in it cover practically anything given a fair wind, if you are legally literate and limber with language. So here are a couple of cases where Articles 5 and 9, my choice for today, are very neatly combined together. Both cases involving the whole question of deprivation of liberty and whether it's suitable in terms of a person's lifelong religion. This first one involving X and someone called MR was a court of protection case. And it was a case about whether it was in MR's best interests to remain at his current home or be moved to a Jewish care home. He had ended up, I think, being stuffed into a care home urgently, maybe to do with COVID or a hospital discharge. And it wasn't the one that he'd had a long-term interest in going to. And he was found to be incapacitated. It was found to be in his best interests that he stayed there. And then his family challenged the regime there and were not satisfied that it was in his best interests. The family was split, so it had to go to the Court of Protection. The man had a life expectancy of between 3 and 27 months. He was deprived of his liberty, as I said, by a straightforward DoLS order, but he ended up going to the Court of Protection on what would have been non-means tested legal aid. So the judge said that this was a classic best interests case involving balancing of many different relevant considerations following other case law and the sections in the Mental Capacity Act. So the judge did a balance sheet approach to the competing considerations, and they looked at the gentleman's will, and that made it clear that he wished to be buried in accordance with Jewish traditions. And it was also clear from the will that he intended to leave money to several Jewish charities, including this specific care home, T, where some of his family wanted him to go. The judge accepted that moving the man would involve a high risk of mortality, but that as he'd been previously a devoted and committed member of his synagogue and Jewish community over many years, upon which he placed a very high value, the likely benefits outweighed the likely risks. And so, because everybody was worried about it and wanted a best interests decision to come from the judge declared that it would be in MR's best interests. He intended to live in a Jewish care home should he no longer be able to live at home. His wishes, beliefs and values when he had capacity, who he was, how he chose to live his life, what he valued, all align with a move to a Jewish care home. And because those wishes were lifelong, it's likely that notwithstanding the risks, he would now, if he wasn't incapacitated, still wish to move to a Jewish care home if he had capacity, so as to live out what little time remains to him with such a community. And so, although you may wonder at our legal system having the time and the space to make this kind of a decision, I'm kind of proud that we do live in a community and in a society where this is possible. Looking at the combination of Articles 5 and 9 in a local government ombudsman's complaint, though, I turn now to Wiltshire, where not such a great job was done. Wiltshire failed to consider religious beliefs when making arrangements for care. They didn't include consultation of all of the family members, but they did consult most of them, and they clearly recorded on an assessment of Mrs. Y that her religion was important to her, and she wished to attend meetings at her local place of worship. There was some question as to whether she could be cared for at home. Classically, with a conversations-based approach underlining assessment, no notes were made on how her wishes would be met. Her wish to go to a local place of worship was not even recorded as a goal or an outcome on her needs assessment. So if this had gone to court, it would have been an unlawful assessment. There was some concern about her mental capacity, and it was decided that she did lack capacity. And it was a close-run case, but it was decided that it was not cost-effective to care for her in her own home, and that there would be risk if she had a package at home, because she would often wander out of the house. So she was placed in a care home, and she wasn't happy. Her husband decided he wanted her to return home, and a specialist care advocate ascertained from Mrs. Y that she wasn't happy either. So there was a reassessment carried out, and at first the evidence was that in fact she had been very unhappy for the first 5 to 6 weeks. But she was doing better now because Mr. Y was coming during the week and not just at weekends. And it was in fact said that she'd settled in well and was taking part in services through her local place of worship via online video meetings, amongst other activities. Mr. Y said Mrs. Y was often upset, but the fact of the matter was she stayed in the care home, and sadly, Mr. Y himself died. So the case went to the Court of Protection, and the court concluded that she was appropriately cared for, except that her religious needs were not being met. So the court determined that in fact, it was in her best interests. It was not an inappropriate placement, but, wagging its finger, her religious needs did need sorting out. And absolutely shamefully, the council took no further steps to search for an alternative, more suitable placement, and recommended to the family that they take it up with the care home. The son made a formal complaint, and the council took 5 months to respond to that, not upholding the complaint in the end and saying that Mr. X should contact the care home directly and sort it out himself. Its excuse, as far as the Ombudsman was concerned, was basically that they didn't have enough staff. So in the end, the Ombudsman found some fault and excused the council for other aspects of the process. The consultation in advance was found to be adequate, but in relation to consider Mrs. Y's religious needs, it was noted, and sternly, that the care plan did not include anything to enable her to engage in her religion. And as far as the Ombudsman was concerned, that was failing to have due regard to Article 9 of the Human Rights Act. The Ombudsman can't find and can't say that a council has breached human rights, but the Ombudsman can say that in the Ombudsman's opinion, the council has failed to have sufficient regard. It had had no regard, so that wasn't a difficult case to make out in upholding the complaint, especially after the Court of Protection had observed that the needs were not being met. The Ombudsman said that that was a strong degree of fault. And the Ombudsman concluded that it was clear from the assessment that her religion was very important to her. So there had been, in all probability, a breach of Article 9 and a breach of the Care Act in relation to well-being, and potentially breaches in relation to the Mental Capacity Act as well. So that brings the material to an end. If I go into the participants list and I invite people to be able to allow themselves to unmute, that will be good. You're now all in the position where anybody can unmute. And can I ask whether people found that interesting? Had you heard of Article 9? Can you think of ways in which it can be made relevant? And would anybody like to actually ask a question? Whilst you're thinking about that, I'm looking in the chat box, and there are some questions in the chat. So I'm going to look at those. Effectively, Jenny enjoys hearing the birds. Yeah, one died last night, Jenny, I have to say. A budgie died. Lynn says, does a DoLS assessor have to visit the place the person is living in, or are they allowed to just phone the care home and chat to the staff before issuing a DoLS order? I think that they are allowed to chat to the staff. I think that in COVID, that became the way forward. And I think that it is being considered to be acceptable even now. I think it is barely acceptable. And I think it depends on what other information that they have got. But it's not the same as whether an advocate has got to physically see the person and be able to exercise their right to meet with them in private. So I don't know off the top of my head, Lynn, but I think that there's a distinction between what the case law says about advocates and what the case law says about the assessments that have to be done. Given that a Care Act assessment should be done face-to-face if there is a concern about incapacity, and given that this can only work, the DoLS safeguards can only work if there is a determination of incapacity, that's why I think it should never be the routine or standard way of doing it. Okay. And Julie has added that. Julie is an advocate. Okay. And Julie says, in particular, if it's the first DoLS, that would be really important to do. Jenny says, if there are any issues, capacity issues or objections, she would flag up to a solicitor that they haven't been visited. They allowed it in COVID, but it is best practice that they should be visited. And there may be some new guidance put out about that. That's great. Yeah. So Sarah said that there was some content in that she didn't know, and that's really good news from my perspective. Thanks for the thanks. Would anybody like to unmute and say anything else? I can't see all of your things all at once. So if I put you on the gallery, I still have to look through. Can't see anybody wanting to talk. So what I will just say is that next week, we're going to look at discrimination, where there is another human right in play, but there is discrimination on top. Different categories of client are being treated differently. And the most famous case about that is the Norfolk charging saga. So if you want to read up about that in advance, please do. It was a case where Norfolk was found to have discriminated in terms of Article 14 of the Human Rights Convention on top of an article that we haven't even looked at yet, which is the first Article 1 of the first protocol, all to do with charges. So that was a case that shows that, in fact, public law and human rights principles apply to something even as prosaic and detailed as charging. Thank you ever so much for your attention. I hope you're enjoying these and everybody knows how to get the PowerPoints. Thank you very much indeed. Bye-bye.